It's nice easing back into old routines. Only now, with extra care. Let's do it for ourselves, for our loved ones, for everyone's safety.
Hurry up, let's go. Let's go.
And staying safe starts at home.
Nice.
From how we work and learn, to the little ways we find joy. If you must head out, take extra care. Making a small effort, being mindful, they go a long way to keeping us all safe. The health of all depends on each one of us. So let's work together, using new tools and keeping to our new habits to protect the people we love. At work, let's all be good team players.
Hi, good morning. How are you? Good.
A little distance between us today will be good for us all tomorrow. A little care can protect the one thing that means the world to us. So let's do our part.
The views and opinions expressed by the speaker, host, commentator, or other third party in ARIVA webinars, e-learning events, and/or virtual masterclass are those of the speaker, host, commentator, or third party and do not necessarily reflect and represent the views and opinions of ARIVA. Furthermore, ARIVA does not warrant, express, or imply the merchantability and fitness for a particular purpose of any product information, service, or process presented by the speaker, host, commentator, or third party, and ARIVA specifically disclaims any legal liability or responsibility for the accuracy, completeness, or usefulness of any product information, service, or process presented. Finally, material or information presentation, opinion, process, or service by, on any trade name, trademark, manufacturer, or otherwise during ARIVA webinars, e-learning events, and/or virtual masterclass do not constitute or imply ARIVA's endorsement or recommendation of such opinion, process, service, item, or organization.
Good afternoon, everyone. Welcome to ARIVA Academy's free live webinar with our topic this afternoon, common legal issues affecting HR managers, HR and labor law challenges in the Philippines, and how to overcome them. So it's a guarantee that you will be learning a lot from our speaker this afternoon. We have a very interesting topic. So let's get started. Now, before we get to know him, I have a few reminders to make sure that our program will run smoothly the whole afternoon. ARIVA is committed to protecting your privacy, hence stricter security of this webinar has been implemented. For better viewing of your Zoom experience, we encourage you to please update your Zoom application by visiting their website. And for those of you who are using their mobile gadgets to view this webinar, you can go to either the Google Play Store or the Apple Store so you can download and install the Zoom app. Now, I want to know who here is joining an ARIVA Academy webinar for the first time. If it's your first time, can you type hi here in the chat box? Also, let us know where you're located. Would love to know where our participants are viewing us from and how is the weather there. A while ago, it was raining hard here in Parañaque, but now it's just drizzling. How about in your location? Hi, Brian. Hi, Daryl. Hi, Bonifacio, who is in Pampanga right now. We have Melissa, who's just in Pasig. We have Brian in Davao del Norte. Wow. Lyndon is in La Union. We have, okay, the chat box is moving too fast. We have Ilona, who is in Camarines. Kathleen, hi, good afternoon, Kathleen. Welcome to ARIVA Academy. Hi, Bridget, who's just in Makati. We have Bernadette, who's in Rizal, and Justin as well. Hi, Christopher. Good afternoon. Welcome to ARIVA Academy. From Nasugbu, Batangas, we have Patricia. From Cavite, Shirlene. Genesis is just here also in Parañaque. Good afternoon, Genesis. We have Elenita, and it's her first time, and she is in Silang, Cavite. Hi, Elenita. Thank you for being here with us this afternoon. We really have a lot of participants from Masbate, Bulacan, Cavite, Lipa, Quezon. Good afternoon, everyone. And to those who have attended in the past, welcome back. We're very happy to have you here again with us. Now, let us do an audio check. I want to make sure that once our speaker is on screen, you will be able to hear the discussion loud and clear. Okay, so let's do this. Type 111 here in the chat box if you can hear me loud and clear. Type 222 if you can't hear anything. Type 2121 if you can hear me, but the sound that you're hearing is breaking up. I sound choppy or laggy. You can also type question mark if you don't understand what is happening. We'll try to help you out. Let me see. I am seeing a lot of 111s. Thank you so much for that. Thank you for that feedback. So later we'll have a break time this afternoon, and I'll be announcing that. Something exciting will be happening also during that break time. Now, participants' microphones will be temporarily disabled by our administrator during the discussion to avoid interruptions. But for those of you who might have questions, you can click the raise hand button during our Q&A portion before we end our session. Just click that raise hand button will allow you to ask your question directly to our speaker. Or you can also type them here in the chat box, and then we'll be reading them during our Q&A portion. An e-certificate of attendance will be awarded to participants who will successfully complete this virtual masterclass. And as proof of your attendance, please make sure your cameras are turned on all throughout the afternoon, all throughout our session this afternoon. Thank you for that. Now, the e-certificates will be available 3 to 5 working days after the learning session. Please also help us build and improve our service with your comments and your feedback. You can scan this QR code that will bring you to the feedback form. At the end of our session, just fill out the form and then send it back to us. We'll greatly appreciate the feedback that you'll give us. There you have it. Now, I'm excited to introduce our speaker. Our speaker for this afternoon studied at University of the Philippines College of Law, University of the Philippines at Los Baños, and he is a distinguished alumnus awardee for labor law and economics. He was also a host of Equal Justice at DZRJ 810 AM, Voice of the Philippines. He was a lecturer in mandatory continuing legal education of the Supreme Court. He was president and legal aid attorney of Integrated Bar of the Philippines, Pasay, Parañaque, Las Piñas, Muntinlupa Cities chapter. He was a professor also in the Philippine Law School. He was chief legislative officer of the Office of the Senate President pro tempore and Senate Committee on Labor. He was Employment and Human Resource Development of the University and the University Legal Counsel at the University of the Philippines. He is the founder of Paladins of Law, a charter member and past president of Rotary Club of Makati McKinley, a member of People Management Association of the Philippines, and a member of Kapisanan ng mga broadcaster ng Pilipinas. Ladies and gentlemen, he's a business lawyer, a labor coach, former executive director of National Labor Relations Commission, founding partner of Sanggalan and Gerlan, business lawyers, and of course, a partner speaker and consultant of ARIVA Academy. Let us welcome Attorney Paul Sanggalang.
Hello, good afternoon.
Hi, good afternoon, Attorney.
Thank you, Kate, for that introduction. Salamat.
You're welcome. Excited to listen to you.
Yeah, this is a very interesting topic. Actually, I had difficulty in looking for the common legal issues because we have only limited time. I think about 1 hour for this webinar. So I really have to, make sure the presentation will fit into the time frame. Allow me to present my slides, Ms.
Yes,
Kate.
please.
Okay.
Let's get this started.
So let's ask our participants. Frequently asked questions. As early as now, you can start asking your question because this is just my biased interpretation of what are the common legal issues and concerns of HR manager. Of course, you are the one who are holding the position of HR manager or HR supervisor, HR associate or assistant. And it's from your point of view that we should discuss this matter. My point of view in this regard, in this topic, common legal issue, depends on what are the questions or the issues and concerns that are being brought to my attention by my clients. And of course, as you know, I also do some pre-legal advice. Also, the pre-legal advice that are sought by the people in my online community. So this is actually bias, or this is just from my point of view, but let me hear from you. What are your common legal issues and concerns that affect you? Hopefully, we will finish the presentation part as soon as possible within probably 30 to 45 minutes. So we will have plenty of time for the open forum. And Miss Kate, you will assist me with the open forum, right?
Yes, of course.
If there might be a barrage of questions, so start asking, and Miss Kate will be screening them, making sure that no same questions is asked twice. And so you can start. Yeah, it's like a survey. You can start encoding your questions in the chat window, right, Miss Kate?
Yes. If ever the case is sensitive, you can send it to me privately, and then when I read your question, I will not be reading your name, so it will remain anonymous. So send it privately to me here in the chat box.
Okay. So this is the topic given to me by ARIVA. I don't know how they figure these topics that they have, but it's really creative. Now, I have to narrow down the parameters of our presentation because of the limited time allotted. Now, as you can see, this is supposed to be for HR managers, no? HR managers, not employers, not business owners, not entrepreneur, but HR managers. Therefore, I would presume that HR managers, because they have attained that level of in the corporate ladder, they are already managers, they have attained a certain level of proficiency on legal issues, particularly with respect to labor law and employment law. So this is not for the beginners. So warning, warning, you're warned. This is not for beginners. This is more deeper than the usual basic intro, no? Intro subject. So when we talk about managing or managers or HR, human resources, and when we relate it to labor law or legal issues, look at the picture here. What can you see? You can see here a carrot and a stick. What does this symbol represents? No? Carrot on one hand and stick. What? In relation to managing people, in relation to dealing with employees, what does a carrot and stick represent? What do you use a stick for? No? So a stick, you use a stick, it's a symbol of punishment. It's a symbol of pain. No, you use a stick to hit someone, to hit something. Let's say, for example, an animal, a horse, no, or a donkey. You use a stick to train. No, when you train animals, when you're an animal trainer, you have to use the basic tools, which is the carrot and the stick. What does the carrot represent? It represents reward, incentive. Do you know how they make dolphins jump, killer whales jump, dogs and circus animal do those tricks? It's through carrot and stick. The carrot represents a reward, a food, or something that will give pleasure, something that will motivate the animal that is being trained. And a stick, of course, is disincentive. No one wants to be hit by a stick. Now, this is no different from raising a child. If you have been a parent or if you have been a child, everyone has been a child of someone, of course, and you're being raised up, you are subjected to the carrot and stick approach. No, this is basic, this is rudimentary. So carrot and stick. Now the problem is we have labor law. Why? Because sometimes the stick is used excessively, no, to the point that the one that is on the receiving end will be abused and oppressed. No, that's why we have labor law, to protect the employees who would be on the receiving end of the stick. And what is the highest punishment that can be given to an employee? It's dismissal, it's termination. Now, what about carrots? Now, employers vary. Some are rich, some are generous, some are really giving, and some are really, not so generous. So, to have a standard on incentives, on rewards, on payment, on salaries and benefits, we have labor law to take care of that. So that's the basic, no? And HR manager, or if you're not, even if you're not a manager, you should be familiar. Now that's why we have all these laws. And I have to select the common legal issues and concerns of HR manager. And we have all these laws. There's so many topics to consider. And one of the bestseller, but which I'm not going to discuss, is the question of the COE, or Certificate of Employment. That remains to be one of the best seller of all the questions that have been frequently asked. Those pertaining to the COE or Certificate of Employment appears to be the most asked. But the thing is, most of the people who ask questions about the Certificate of Employment are not really HR managers. They are more of employees who have resigned or have left their companies. So we go to what legal issues and concerns affects managers most. And it is, drum roll, termination. Termination of employment. Why? Why do I say this? Do you know that the most frequent type of labor complaint that is filed with the DOLE or with the NLRC, the labor arbiter, is an illegal dismissal complaint? That is the most prevalent, the most common, the most numerous types of cases. And illegal dismissal includes constructive dismissal. And when you say illegal dismissal, it includes whether it's a disciplinary or it's due to personnel reduction. So these are some of the examples that you can hear from an employer when they want to remove or terminate the employment contract of an employee. You're fired. Sometimes employees are forced to resign now, or they are treated unfairly, they're ostracized, and in short, they're being told you're not welcome here anymore. And this results to these labor cases classified under illegal termination or illegal dismissal, including constructive dismissal. So from my point of view, because we have only 1 hour, we will concentrate on termination law or illegal dismissal, constructive dismissal related issues. No? And I'm sure there will be a can of worms when we start discussing illegal dismissal, illegal termination, even constructive dismissal. It will not be enough even for our 1 hour time slot. So start asking those questions. But of course, if you have other topics, other areas of concern, yes, we will accommodate that during the question and answer portion. So you can still send questions not related to dismissal. You can send questions related to labor standards like minimum wage, like overtime. You can send questions about occupational safety and health and other regulatory concerns. As long as there's still time, we will answer all your questions. Okay, so why is illegal dismissal such a big hit when it comes to frequency, when it comes to legal concerns or problems of HR manager? Why? Because the consequences of illegal dismissal is really, yeah, as you can see from here, the list of the possible adverse consequences to the company, to the employer, is listed here. Number 1, reinstatement. So you have this person that you want out, you want to let go, you don't want to be in your company anymore. And then here comes the government, the labor arbiter, or the Department of Labor and Employment, saying that you have to reinstate him back to your company. That's a difficult situation, no? When you have an employee that you have already fired because he's not helping, he's not performing, he has an attitude problem, he has committed some unacceptable behavior or conduct, and then the labor arbiter is telling you to take him back, absorb him back. No, of course, there's an alternative. If that's no longer feasible, then there's always separation pay. But the principal remedy of an employee who has been illegally dismissed is to be reinstated back to his former position or an equivalent position if the former position no longer exists, without any loss of seniority rights. Meaning that for those period that the employee is out of work because he has been laid off or dismissed, he is going to be considered to not have a break in his employment. So he will be qualified for promotions as if he has been serving the company all those period of time wherein the case is pending. And here's one of the biggest consequences, dire consequences, the accrued wages from reinstatement. Do you know that if a labor arbiter has ordered the reinstatement of an employee after declaring that the employee has been illegally dismissed, no, the employer has 10 days to reinstate that employee. What if the employer appeals, no? Because there's the remedy of appeal. Within 10 days, the employer can go up to file an appeal. Now, the problem is, even if the appeal wins, no? If the employer appeals and he wins in the appeal, that reinstatement order is considered to be immediately executory. And if the employer does not comply within 10 days to reinstate the employee by virtue of the order of the labor arbiter, what happens? Accrued wages will happen. So what does that mean? Even if the employer wins in the higher court, in the appeal, in the Court of Appeals, or in the Supreme Court, the employer cannot escape paying accrued wages to an employee who has been validly dismissed. So you would be scratching your head. How is that? I thought I won the appeal. I thought when you appeal and the decision of the labor arbiter is overturned, then the dismissal is valid. There shouldn't be any payment to the employee. Well, logically, that's correct, logically, but legally, that's not how it is. If you will read the labor code, this is from the labor code, the accrued wages. The labor code provides that even if the employer appeals and wins an appeal, the reinstatement order issued by a labor arbiter is immediately executory. So that means that even if the decision of the labor arbiter is declared to be a wrong decision, the reinstatement order must be respected. And what does it mean? It means that if the employer has failed to reinstate the employer has to pay the accrued wages. So what happens? Even if the employee lost the case on appeal, the employee will still be entitled to accrued wages. And that can be a substantial sum of money. Now, of course, you all know about back wages. Attorney's fees, this is an additional award. This is 10% of the award. And if there's bad faith, we have moral and exemplary damages. Legal interest happens at 6% per annum because there are times that the decision, if there's a monetary award, is not paid immediately. So it will earn 6% per annum until fully paid. Cause of suit, this is when an employee is not qualified to sue as a pauper litigant or as a indigent litigant, and he's not allowed to sue for free. He has to pay the docket fees of the Court of Appeals or the Supreme Court. Cause of suit means that all his legal expenses would have to be reimbursed by the employer in case the employee wins. So these are the dire consequences. But the most dire of all these consequences is, of course, reinstatement and the accrued wages. Now, back wages, this can balloon. This can balloon. If the case takes up a long time before it's finally decided, the back wages will increase and increase and increase every month. Every month that the case is still not final, the back wages will increase and increase. So every month, it's 1 month salary, additional award per month, no? 1 month salary until the case is finally decided. And that's why many HR managers have to decide whether to settle or to appeal. This is one of the biggest concerns of a lot of HR manager. It's a decision point, whether to appeal or just to accept the decision of the labor arbiter. Because the problem is, as the case goes on, as it is prolonged because of the appeal, when you go to the NLRC division, when you go to the Court of Appeals, and when you go to the Supreme Court, the stake gets higher and higher and higher until it reaches millions of pesos, even if there's only one employee filing the case. So that's a very difficult situation. So even if you're an HR manager and you believe that you have a good case, you have evidence, you have a good attorney, you will think twice before you consider going up on appeal, because the award can only get bigger if you keep losing the case. And if there's a reinstatement order issued by the labor arbiter, remember, there is the danger of accrued wages. So even if you win on appeal, you will still have to pay. No, you will still have to pay if you don't execute, if you don't comply with the reinstatement order of the labor arbiter. Okay, so if you have questions, keep the questions coming. We'll try to manage time. So at the heart of the termination cases is the question about security of tenure. What does security of tenure means? Now, we have Executive Order 51 that defines security of tenure. Executive Order number 51 is issued by President Duterte in 2018. And this is the modern definition of security of tenure. We have the definition of security of tenure in the labor code, but that's 1970s vintage. No? So this is the modern definition of security of tenure. What is security of tenure? It refers to the right of employees not to be dismissed or removed from their employment without just or authorized cause. We'll discuss what just or authorized cause is. But if you're an HR manager, I suppose you know that. Observance of procedural due process, consistent with the Constitution of the Republic of the Philippines, which is, we now have the 1987 version, and the Labor Code, which is 1974 vintage, as amended by prevailing jurisprudence. What are jurisprudence? These are the final decisions of the Supreme Court, which have doctrinal value. Okay, so remember the definition as we go, no? As we go in discussing the legal issues and concerns of HR managers. Now, what are just causes? In short, in a nutshell, just causes are justifiable reasons or grounds that can be used to validly dismiss an employee based on the employee's attitude, behavior, conduct, or performance. Okay, so it's an unacceptable attitude, unacceptable behavior, unacceptable performance, or unacceptable conduct that is serious in nature. So in short, when there is just causes, the employee has committed some wrongdoing, some violation, some breach that will be the valid reason for the dismissal from employment. Now, we have Article 297 of the Renumbered Labor Code, formerly Article 282. And as you can see, it's a very short list. It's a very short list. Based on this short list, we will know that it's going to be difficult to dismiss an employee. Think of a possible ground and look for something related to this list. If it's not in this list, then you cannot dismiss an employee. That's the rule. That's the meaning of security of tenure. Let's go back to the definition of security of tenure for reference. You need to have just cause or authorized cause. If you don't have just cause, that will mean that the dismissal is illegal dismissal. Okay, so go back to just causes. These are the lists. It's a very short list. Now, look at the list. Is there anything mentioned about key performance indicators, KPI? How about poor performance? How about attitude problem? If you have an employee with an attitude problem, where will it where will it fall? How about cultural fit? Is not fit in our company's culture. Where can you find that here? So the problem with Article 297 is this is a very short list. So there's a solution. Moving forward, there's a solution. It's the last ground. Other causes analogous to the above. Now, what is the meaning of the word analogous? Analogous is synonymous to similar. No? When you say analogous, it means similar to the above. Ibig sabihin, it means that an employee can be dismissed through analogous causes or similar causes when they are similar to any of the above causes. So that's why we need to memorize serious misconduct, willful disobedience, fraud, or willful breach of trust, because that is our key in defining what analogous causes is. Now, we have DOLE, Department of Labor, Department Order number 147-15. And according to this regulation issued by DOLE, in coming up with analogous just causes, it has to be written down in a company policy. And this is the source why HR managers, the HR department, has to come up with a code of conduct, code of discipline, or code of ethics with a list of offenses. The purpose of the COC or code of discipline, code of ethics is to expand the very short list in Article 297. So it's a very short list. If you want a longer list, grounds to dismiss an employee, let's say you want to include performance-related grounds for dismissal, then you need to have a written company policy. So that becomes the legal issue or concern. You have to write down a policy and you have to make it known to the employees concerned who will be affected or covered by such policy. And according to DOLE, Department of Labor and Employment, whatever policy you have to write down, it must be lawful and it must be reasonable. And here's the standard. Since we're talking about analogous or similar causes, it must be similar or analogous to Article 297 just causes. So for the code of conduct, code of discipline, or code of ethics prescribing the penalty of dismissal, it has to be similar or analogous to the standards in Article 297. And let's go back to Article 297. These are the standards. These are all serious offenses. Serious misconduct is different from simple or minor misconduct. When you say serious misconduct, it's really a grave offense. So willful disobedience is different from simple disobedience, because there are many situations wherein an employee does not follow orders, but it's not willful. When you say willful, it means rebellious, defiant, malicious disobedience. Fraud, willful breach of trust. There are many times that an employee breach confidentiality. But if it's not willful or fraudulent, then it's not going to pass the standards for terminating an employee. Many times an employee can be neglectful of his duties and responsibilities. But if it is not habitual and gross, when you say gross, it has to be serious. Serious means gross. No? So unless it is grave, serious, and gross, and at the same time habitual, then neglect of duty is not a valid ground to dismiss an employee. Of course, everyone knows what a crime is. When you say it's a crime, it means that a person, the employee, can go to prison if he's convicted by a final decision. So this is the standard. This is the standard. So going back to the legal concern or legal issues affecting HR manager, when you draft your code of conduct, code of discipline, or code of ethics and list down all the offenses and violation that can probably lead to the dismissal of an employee, you must make sure that you're following the standard, because analogous means similar. So I'll give you a concrete example. Excuse me. Habitual absenteeism. Do you know that there are many instances wherein an employee who has been dismissed because of habitual absenteeism is declared to be illegally dismissed? Yeah, we have many employees. There are many decisions decided by the Supreme Court, even by the labor arbiter, that says that dismissal is too harsh of a penalty when it is imposed to an employee who, based on the frequency of his absences, was dismissed by the employer. How come? How is that? We have a policy. You will say, we have a company policy. We have a code of conduct that says when an employee reaches this number of absences in a certain period, they are declared habitually absent, and the penalty would be dismissal. And then here comes the labor arbiter saying that, no, that's too harsh. That's the penalty is not proportionate to the offense committed. So you would be taken aback. Why would the labor arbiter say that the penalty of dismissal is too harsh? We have a written policy. We have a written policy that habitual absenteeism will be penalized by a dismissal from employment. Now, you have to put yourself in the shoes of the labor arbiter to understand why the labor arbiter is saying that it is too harsh. Remember, the standards is Article 297. These are the standards for dismissing. If you will look at this list, these are capital offenses. These are heinous crimes of an employee against an employer. So to be able to dismiss an employee, it must be proven, it must be shown that the employee has committed the highest possible offense, the most serious of all offense, the most heinous of all offense that an employee can commit against the employer. And simple absences, even if it's frequent, might not necessarily be in accordance with the standard of neglect of duty. Not reporting for work is a neglect of duty. We all know that. Not reporting for work, being habitually absent, is a neglect of duty. It's also habitual because it's habitual absenteeism. But the question is it gross? Or is it serious? Or is it grave? When we talk about seriousness or gravity or magnitude of the offense, we're talking about how did the absences of this employee affected the company, the business, the clients, the deliveries, and everything. How did the frequent absences of the employee affected the operation, the delivery? Can you quantify it in terms of money, in terms of pesos? So if the absences, even if it's habitual, if it is not serious or grave enough, then the labor arbiter will say, oh, the dismissal, it's too harsh. You could have just suspended the employee. And when you dismiss the employee, since the penalty of dismissal is too harsh, therefore the dismissal is illegal because it's an over what you call this, an overreaction on the part of the employer. So that's one of the major concerns of HR manager. When is dismissal too harsh? And when is it just right? Okay. So let's look at this diagram for just cause dismissal. When you're an HR manager, of course, you know the procedural due process. You already know the basics. And I'm sure you have Department Order 147-15, series of 2015 as part of your reference material. So you know the requirements of notice and hearing. You know that you need to conduct an administrative investigation and conference before you can dismiss an employee. As an HR manager, you wouldn't become a manager if you don't know the basic. Now here's the problem part. The evidence part and the reasonableness part. A lot of my clients who are already HR manager, or HR director or an HR partner or even an HR consultant do not have problem regarding the procedural due process. They know. They even have templates. It's already templated. They know the process. They know the basic requirements, but they're having trouble in these two areas: evidence and reasonableness, good faith reasons. And that is where they usually lose out in a labor case. If the evidence is not enough, the evidence is not substantial, then the labor arbiter might say, the evidence does not support the conclusion. The conclusion is dismissal. Your evidence is not enough. Therefore, the labor arbiter will say the dismissal is illegal. So oftentimes, my clients would approach me and ask me, attorney, look at our documentation, look at our evidence. Is this enough? What do you think? What will the labor arbiter say? Will the labor arbiter say, we made the right decision when we dismissed this employee? And so they ask me to evaluate based on the documents, based on the record, based on the proceedings, the witnesses that they have, whether they can pull the trigger and fire the employee. So yeah, that's one of their common legal concern, the weight of the evidence. Because they have experience. They have experienced cases wherein they dismiss an employee and then later the labor arbiter said the evidence is not enough. Now, another matter that they consult with me is, attorney, we've done all the procedural aspect. Now we're ready to make a decision whether to dismiss the employee or not. Attorney, if you will evaluate this, the documentation that we did, the process that we did, the procedure and everything, do you think we are in good faith? And will our decision be reasonable under the circumstances? Why do HR manager ask this question? Because there's such a thing as good faith, bad faith rule in labor law. Even if you comply with Department Order 147, you had notice, you had hearing, you have all the paperwork and everything. If the labor arbiter determines that the employer is in bad faith, then he might declare that the dismissal is illegal. What are the examples of bad faith? Bad faith, one common example is that the decision is premeditated. The termination is really a done deal. The employer is just going through the process, going through the procedural aspect and documentation, but their mind is made up. The mind of the management is already made up, and there's really no due process. Because it's like a kangaroo court, no? It's the outcome is already predetermined. That's one example of good faith, when it is premeditated, when the employee is already marked for dismissal, and you're just going through the process. So that's one indication of bad faith. Another is you just manufacture the evidence. That's clearly bad faith. When there's really no evidence, but the evidence is manufactured, fabricated, that's bad. That's clearly bad faith. Also, afterthought. Afterthought is also considered bad faith because there are times when the employer only do the procedural aspect, the paperwork, the documents, after they have actually dismissed the employee. No, when the employee is all actually been fired already. He was actually fired, and then the HR manager learned, oh no, Why did you fire? We have not done the procedural due process yet. And then you try to backtrack, you try to make everything right through documentation, but actually the employee was fired earlier by the president or by the manager, the operations manager who doesn't understand labor law, and he was already fired. And then here's the HR manager trying to fix the situation through documentation. That's called afterthought. And that's also considered bad faith. Also, retaliation. Retaliation is also considered bad faith. Why? Because let's say an employee who has a grievance, who has a dispute or an argument with his boss, and then after several days, he gets dismissed. No? So it's a timing that's important in retaliation. And was there a prior incident wherein there's a altercation, argument, disagreement, or a complaint that the employee filed, and then later on he found himself out of job, dismissed? So that's retaliation. Those are some examples of bad faith. Also, reasonableness, no, not related to good faith, bad faith, but reasonableness. There are certain situations that are unreasonable. Depending on the industry that you're in, there are zero tolerance policy. No, depending on the industry, there are zero tolerance policy that, from the point of view of other companies, businesses, or industry, appears to be too harsh. Like I know that there are zero tolerance policy in bringing in some companies that have intellectual property, proprietary rights regulations. Employees bringing in thumb disk, class disk, wherein they can download information. There's zero tolerance. If an employee brings in a flash drive that can possibly download certain proprietary rights, there's a zero tolerance policy, and that employee can get dismissed. Now, bringing in a thumb drive in just an ordinary company, an office, it's not a big deal. Everyone have their thumb drives. Some people even use thumb drives as keychain or necklace. But in some company, they have zero tolerance, and they don't allow that. Now, if that company discovers an employee who brings in a device like that and then terminates him, how do you think would the labor arbiter decide the case? So from the point of view, ordinary businesses, ordinary industries, ordinary company, thumb drive, it's just something that everyone has nowadays. Okay, so would the labor arbiter consider that dismissing that employee too harsh? So those are instances, no? Is it reasonable to dismiss the employee? So these are the questions that often affects HR manager in making decisions. And of course, the HR manager receives pressures from the clients, from the top management, saying, "We don't want this employee anymore. You have to fire him." So the HR manager would have to consult a lawyer to find out whether it's safe to dismiss or not. Now let's go to authorized causes. So what's the difference between just cause and authorized causes? Authorized causes are valid grounds for dismissal, wherein the employee did not commit any wrongdoing, has not violated anything, has not breached anything, but there is just economic, financial, or technological reason, or even health reason for the employer to let him go without the employee's fault. So these are the lists of authorized causes under Article 298 of the Renumbered Labor Code, formerly Article 283. And it's limited to this causes only. Now, what if, now this is another concern for HR manager. So they say, attorney, here's my problem. I don't have evidence. don't have substantial evidence. And we might not have good faith or reasonableness. Attorney, can I dismiss this employee because top management and our clients are telling us to let go of this employee? Can I use authorized causes? We're willing to pay separation pay. We're willing to give the required notices. It's just that the employee is undesirable. Our client doesn't want him anymore. Our top management doesn't want him anymore. But based on your assessment, there is no just causes. There's no substantial evidence, and we might be having problem with reasonableness and good faith. Can we use any of this? Like, for example, redundancy. Can we just pay him separation pay and then let him go? That's one of the common questions asked of me by my clients, because they know they don't have sufficient reason, sufficient evidence, sufficient ground for just cause dismissal. So they want to know. Now, the answer is obvious. And no, you can't resort to this. You cannot resort to this. Why? Because if you want to resort to authorized causes, you have to comply with the requirements of Department Order 147-15. No, and there are certain elements and requirements before you can do so. Let's take, for example, redundancy. What does redundancy mean? Redundancy means that you are overstaffed. You have excess manpower than what you actually reasonably need for your business. That is redundancy. So because of redundancy, you have to reduce your headcount, or you have to abolish certain positions that are not needed. And that's allowed under the law because the employer is not required to support a payroll, no, an overhead that is inefficient and that it actually doesn't need. So redundancy is allowed as a valid ground as long as you comply with all this requirement. So separation pay is easy. That's an easy requirement. Many employers are willing to pay the required separation pay of 1 month per every year of service. Many employers can comply with a 30-day notice to the Department of Labor and Employment and to the employee prior to the effectivity of the layoff. But here's the problem. Do you have substantial evidence to justify redundancy? Do you have good faith reason to justify redundancy? So it's not just paying the employee separation pay and just giving him a 30-day notice and say goodbye. Even if you ask the employee to sign a quit claim. So many questions would be like this. Attorney, can we ask the employee to sign a quit claim? Anyway, he will receive handsome separation pay. We will give him 30 days notice, even give him a terminal leave and probably additional amount just to let him go so we don't have any problem anymore. And then we will ask him to sign a quit claim, a waiver and quit claim, so that he will be prevented from filing an illegal dismissal case. Will that work, attorney? And my answer is yes, it might work. In some cases, it might work. Yes, but it might not work in other cases. Some employee will just take the money and go and just move on, move forward, charge it to experience. But some employees, they would like to fight for their rights. And if you encounter an employee who knows, who believes that he was badly treated, even though he already received separation pay, even though he already signed a quit claim, no, that will not prevent him Receiving separation pay and signing a quitclaim, even if it is notarized, will not prevent that employee seeking justice, quote-unquote justice, from filing an illegal dismissal complaint. If he believes that there's really no redundancy, redundancy is just made up, it's manufactured, and the company really wants him out. How can he prove that there's no real redundancy and it was only manufactured, fabricated, made up, make-believe, just to fire him? There are several indicators of bad faith. Like, for example, after he's already out of the company, the company starts hiring. Yeah, they start hiring his replacement. That is one clear indication that there's really no redundancy, because if there's redundancy, then for a reasonable period of time, the company would not rehire a replacement. So if that happens, let's say signed notarized quitclaim, receiving separation pay, 30 days notice and everything, all compliant, and then after you hired the replacement, and then what you get? You get summoned by the labor arbiter telling you that the employee filed an illegal dismissal complaint on the ground of there's no valid authorized cause. So, what's the solution? What's the solution if you don't have any just cause, and if you don't have any authorized cause, and you really have to let go of the employee? What's the solution? One solution, but this will not work every time. No? One possible solution is you negotiate for a voluntary resignation. Now, it will not work 100% of the time, but if you have a good rapport with the employee, if you have good personal relationship skills, then you might be able to negotiate with the employee without offending him and offering him handsome financial assistance and ask him, would you consider voluntary resignation or even early retirement? And of course, it has to be voluntary on the part of the employee. The employee has to submit a resignation letter or an application for early retirement. It has to be voluntary. You cannot force the employee to accept your offer of early retirement or voluntary resignation. So that's why you have to make it sweeter, no? You have to add sweetener, provide more benefits that the employee will receive to convince him to leave. So as I said, that's not 100% successful in most cases. It depends on the situation, but it's a possible solution if you really want the employee out and you have no authorized cause or just cause. Then, if he does not want to retire early or resign voluntarily, then you have to let the employee remain with you. Otherwise, you'll have an illegal dismissal case on your hands. Now,
Attorney, before we move forward, is it okay if we go on a quick break?
okay, sure. No problem. Anyway, we're moving to another topic.
Okay, thank you so much, Attorney. Hi, good afternoon again, everyone. So we're going on a break, and this time we're doing something exciting, okay? Because we are going to play a game, and this game will have two winners. We're looking for two winners. Each winner will be receiving 200 pesos. Imagine you're here attending a free live webinar, learning from our speaker, but you don't know, pwede ba kayong maging 200 pesos richer? Okay, this one will be sent to your GCash account. And the game is very easy. If you've attended in the past, you're familiar with this game. The game is called It's called Guess the Movie. Ayan. So this is how the game goes for the benefit of those who haven't seen this game yet. We will show you short clips or short trailers of a particular movie. Kailangan ninyong gawin, you have to be the first one to type the complete and correct title of that movie here sa chat box. Kailangan talaga pabilisan ito. But reminder, complete and correct title. Okay? For you guys to get the feel of the game, let's do a sample run. Trial pa lang, but I want you to start guessing the title of this movie.
It's Megalodon.
He's kidding, right?
That thing's out there. We need to find it and kill it.
Why don't you just put a tracker on it? Did you guys ever watch Shark Week?
There you go. Ayan. The answers are Meg 2, Megalodon. We have The Meg, Titanic, The Meg 2. Those are the answers I'm seeing. What's the title of that movie? It is The Meg. Okay, ayan ha. Again, just a reminder, complete and correct title. So bawal yung may kulang na words, bawal yung sobra yung words, bawal din yung typo error. So it has to be the exact title. So now you know how the game goes. This next clip will give you 200 pesos. Let's watch it.
I know you're there. Your shadow has been following me ever since I was small. Don't be afraid.
There. Okay, here are the answers. Titanic, Under the Sea, Little Mermaid, The Maleficent, Cinderella, The School of Good and Evil, Maleficent, Maleficent. There are different spellings of Maleficent. Rapunzel, Maleficent. Okay, Little Mermaid, The Little Mermaid. Let's reveal the title of that movie. And do we have our first winner? And it is Maleficent. So the first one na nakakuha ng tama na answer, we have Marie Noe Pereja Juanilio. Congratulations! Marie Noe. You will receive 200 pesos. So this is what you have to do. You have to send your GCash account number privately. Please send it to us directly. ARIVA Academy Philippines. Look for that account here in the chat box and send your GCash account number privately, okay? Don't send it to everyone, please, because you're protecting your data. Send it to us privately and wait for your prize. We'll be sending it within this afternoon. Now, Marie Noe, because nanalo ka na, you won't be able to join the game anymore, okay? Because you've won. So, you'll just have to watch and give chance to your other co-participants. Again, congratulations. Now to the rest of our participants, don't worry, we have one more 200 pesos at stake. Baka sa inyo na to, so let's watch this next clip. There! Ayan, ayan, ayan. So we have Space Jam. We also have Space Jam. May nag-type ng Space Jam but 2 words. Meron nag-type ng Space Jam 1 word. We also have Bugs Bunny. We have High School Musical. Anne-Marie, ano ba yung napanood mo? What are the other answers? Looney Tomb's Space Jam. Let's reveal what's the title of that movie. And yes, it is Space Jam. So the first one, 2 words siya, separate. First one, talaga nga namang napakabilis niyang mag-type. We have our second and last winner, Ken Chua. Congratulations, Ken! Best talaga ni Ken. Parang first scene pa lang, alam na niya na i-type na niya agad yung answer. So you've won for yourself 200 pesos, Ken. Congratulations. So send your GCash account number to ARIVA Academy Philippines here in the chat box. Please send it to us directly, okay? And then wait for your prize. We will be sending it to you. So congratulations, Marie Noe. Congratulations, Ken. And to everyone who joined, thank you. I hope you guys had fun. Na-enjoy ninyo mag-try manghula ng mga titles ng movies. Congratulations again to our winners. Now, I'll move to my other announcements. Here goes. Stay on top of our insights and updates. Stay connected with ARIVA Academy. You can visit us on social media. You can join our ARIVA Academy Facebook group. You can also like the Facebook page. You can follow us in LinkedIn. And also, you can check out our website, ariva.com.ph. I am also inviting everyone to be a part of the growing ARIVA Academy Viber community. Scan the QR code and instantly that will bring you inside our Viber community. So we're looking forward to seeing all of you there. Now, for those of you who might have missed the free live webinars that we had in the past, lalo na sa mga first time pa lang na magjo-join ng aming free live webinars. Starting 2020, we have already a lot of free live webinars. And don't worry because you can all catch them via our YouTube channel. So all you have to do is subscribe to these channels, ARIVA Academy and ARIVA Talks. Now, for those of you who are interested in inviting our speaker, like Attorney Paul, to conduct a program exclusive for your whole team or your whole company, we can help you out with that. Give us a call at 0916-695-4418 or send us an email and then let us know what topic you need. Here are some of the programs that we offer, but we have a lot more than that. So call us, email us, and then we will help you partner with the right speaker under ARIVA Academy Speakers Bureau for that. Now, let me invite you to some of our other upcoming learning events. We have a lot for the rest of the month. Here are some of them. Now, on Wednesday, we have another free live webinar and another interesting topic, AI and ChatGPT. How ChatGPT and generative AI will shape the future of work. This will be on September 6th already, so join us. Another one is on September 13. This is another masterclass, Company Policy, Elements of Administrative Investigation and Progressive Discipline. I'm sure our HR practitioners here will find this very helpful. This will be on September 13. The next one is September 14 and 15, MS Excel Bootcamp, Intermediate to Advanced MS Excel Skills for Office Productivity. How to effectively terminate a problem employee and avoid costly illegal dismissal cases. This is our topic that will be on September 20. Ayan. Again, the topic on September 20, how to effectively terminate a problem employee and avoid costly illegal dismissal cases. You'll find this very useful, so join us September 20. The 8 effective technical and report writing skills for peak performance will be on September 21 already. On September 27, the purpose-driven employee, developing purpose-driven organizations to increase employee engagement. Guerrilla selling strategies in today's dynamic business landscape. This will be on September 27 as well. Strengthening communication skills at work on September 28, and also on the same day, decoding property transfers and taxes. Another free live webinar will be on October 3. This is for next month. Topic is employee engagement as a competitive advantage. Another one, October 6th, Horenso, Japanese philosophy, effective communication skills in the workplace. Still, it's a free live webinar. So there you go. Those are the programs for the rest of the month and early next month. If ever you're interested in any of them, all you have to do is go to our website, ariva.com.ph, so you can register online. Okay. Now, I won't be taking much of your time. Marami pang i-discuss ang ating speaker. Attorney Paul, I'm giving the floor back to you.
Okay. Thanks, Kay. Okay, allow me to pull up my slides once again.
Yes.
May mga questions na ba?
We
there
have
questions
a
already?
lot, attorney. So just keep them coming, everyone. We will be reading them
Sige.
later.
Sige, let's baka maubusan tayo ng time eh. I have several slides pa. So let's give way to probably 2 questions.
Oh, okay. Let me just go up. Medyo. One moment. Or I will go to the first question that I have here.
Okay.
Here's a first question, Attorney Paul. Are the rules for managers and supervisors regarding disciplinary action the same with rank and file? Interesting question yan.
Yes, basically yes, except for one thing. Isa lang yung pagkakaiba, no? So the question is the rule for rank and file and for managers and supervisors in terms of proper disciplinary process in compliance with labor law the same? The answer is yes, except for only one thing. That is, managers and supervisors occupy a position of trust. No, trust and confidence. Why do they occupy a position of trust? Because they are considered agents or representative of the employer of the company. When you're promoted to a supervisor, you're already part of management. And once you are part of management, you're an officer, an executive, a manager, a supervisor, you wear 2 hats, no? Dalawang hat na na sinusuot mo. One is the hat of an employee. You're still an employee, di ba? You're still an employee. But the other hat that you wear is you're an agent or representative. So, special na yung position mo. Hindi ka na rank and file. You are part of the management already. And as part of the management, no, one reason to validly terminate someone who is part of management is loss of trust and confidence. Now, why? Because as a representative, as the face, you are the face of the management of the employer of the company. You occupy a special position, and if you lost the trust and confidence of the employer, then that's a valid ground. How can you lose such trust and confidence? Now, the requirements are provided in Department Order 147-15, no? So we don't have time to enumerate all the requirements, but in a nutshell, no? In a nutshell, if you committed an act or omission, or let's say you have to do something based on your responsibility, but you did not do it. Like, for example, tolerating violations, no? So you're in a position of responsibility, you're in a position of authority, and if you tolerate violations, even if you are not the one who committed the violation, it's a rank and file and some of your colleagues, you tolerated, that can lead to loss of trust. Also, if you have certain duties and responsibilities, since you're no longer rank and file, you're being paid by the employer based on the responsibilities that you have. No? So you're no longer paid based on time or the time you spent working. You're paid based on results or the responsibility that is on your shoulders. And if you're not able to discharge effectively those responsibilities, it can be a cause of loss of trust. So those are also conflict of interest. No? Conflict of interest. Those are some of the reasons why you, a manager or a a supervisor can be terminated. Okay? Next question, our second question before I continue.
Here's another question. It was sent to me directly. The scenario is of a terminated or dismissed employee who is not claiming his final pay after 30 days, despite notice provided via email and registered mail. As an employer, what else do we need to do? Or do we just wait for him within the 3 years to claim it? Background is the employee was terminated with just cause and filed to SENA illegal dismissal, but it was proven that he was given due process and he was terminated with just cause.
Mhm.
So what do they do? What does the HR do, attorney?
Okay, if there's a labor case, if it then you inform the labor arbiter that the final pay is ready for collection. So at least you have to put it in record. No, it's good that you already sent an email and registered mail, but just an additional safety precaution is that if there's a labor case or a SENA, you put it on record that the employee just need to claim it, so that you have an additional document that will show you are not holding on to the amount, and the employee can collect it anytime that he's able to. Okay, so Miss Kate, we will continue with the
Yes.
presentation. Okay, so we've discussed aspects on dismissal. Now, here's another common legal concern or issue. It's the proper classification of employment status. Now, many HR manager, they're already HR director, still commits mistakes. And when you commit mistakes regarding classification, it's called misclassification. Now, why is it important to properly classify employees? Because if you misclassify an employee and you dismiss them based on the wrong notion, wrong idea, then that can lead to illegal dismissal. Example, if you thought that the employee, you classified him as a project employee, but based on the assessment of the Department of Labor, the labor arbiter, he's actually a regular employee. And then the project ends, the project is completed. So you tell the employee, since you're a project employee, the project already ended, we're letting you go. No, there's no more reason for you to be our employee. The project ended. But if the employee files an illegal dismissal case and later it is found out that he's not a project employee, he's actually a regular employee because of certain facts and circumstances, then you will be held liable for illegal dismissal. Why? Because of misclassification. So the same happens when you thought that the employee is contractual or under a fixed term employment contract. You thought the employee is seasonal or casual or probationary, when in fact he's already regular. And that happens many times. And even for experienced HR manager, they commit an error, they commit a mistake, and that will cause a lot in terms of consequences. Because if you did not go through the due process, no, if you did not go through administrative investigation, having a just cause or an authorized cause, and going through procedural due process, and you are mistaken based on wrong classification, then it will lead to illegal dismissal. So let's review. No? Every HR manager should have a strong foundation on employment classification. And based on labor law, these are the classifications that are available. So it means that if you have an employee, you must be able to know where they fall under. What is their employment status? And these are the only available status that we have. There are many hybrids and variants, but they have to fit in any one of these status of employment. So, but there are some hybrid or some complicated type of employment arrangement where employers and HR manager finds it difficult. What if they're paid based on commission? Where do you put an employee who is paid based on commission? What if the employee is a reliever? How do you classify a reliever? Is it regular, casual, probationary, project? What if it's part-time? Yep. You cannot have a classification outside of this classification. You have to look for a classification within these employment statuses. So that's the difficult part. How do you classify a reliever? How about an employee who's on call? How about an employee who's paid based on results, like commission based or paid on a per job? Where do you classify an employee like that? Part-time? Or you have to pick. You have to pick one. And because of the many types of work arrangement, HR manager finds it difficult to select. Where do I place, for example, an employee on a work pool, an employee who is on a Pacquiaoan in terms of compensation? So that's a difficulty. Now let's dissect. How? Now, the reason why employers and HR manager finds it difficult is that they don't know what this classification is all about. The employment status classification is about security of tenure. Security of tenure. It's not about how many hours. It's not about how the employee is compensated. It's not about whether the employee is on call or a reliever. It's not about the work arrangement. It's not about how the employee is paid or compensated. It's about security of tenure. So that's the key. In determining the classification of the employee, even if he's a reliever, you'd have to find out what kind of security of tenure does he have. A reliever can be a regular employee. Yeah, that might be a strange idea for you. A reliever, a regular employee, a part-time employee can also be a regular employee, because employment status is not about work arrangement. It's about what kind of security of tenure does the employee have. And finding out the security of tenure will help you determine the employment status. So let's define. What is security of tenure? It is the right of the employee not to be dismissed or removed from his employment or his job without authorized cause or just cause. So what about regular employees? Do they have security of tenure? Of course they have, but their security of tenure is limited based on their age. When an employee reaches the age of 65, which is the default compulsory retirement age, even if they have security of tenure, they have to go. The employer has the right to retire them compulsorily. No? Age 65. Now, the age of retirement can be negotiated under a contract. There can be an earlier age of retirement based on a contract. It doesn't have to be 65. In some companies, the age of retirement is as early as 50. No, if that's what provided in the employment contract, then a regular employee can be compulsorily retired at the age of 50 based on the provisions of the employment contract. And that employee is a regular employee. Now, what about casual employee? So the two main distinction in terms of employment status is regular or casual, although because of the 1987 Constitution and recent jurisprudence, the word casual has been diluted, and it's now a gray area. That's why no, yes. My answer is no, yes. Because if you're going to go to the original text of the labor code, casual employees do not have security of tenure. The employer can at any time tell them, you stop working, this is your last day. So that's the idea of having a casual employee compared to a regular employee. A regular employee, why does a regular employee enjoy security of tenure? Because their work, the activity that they do, is usually necessary and desirable to the usual business or trade of the employer, meaning they are essential. They are performing functions that the employer will require until the company closes down. That's the essence of regular employment, because they're essential and they perform activities and work that that the company will need until it closes down. Their security of tenure is until age of retirement. Now, what about casual employee? What's the distinction between casual and regular employee? It's the activities that they do. Casual employees perform casual work or casual activity. These are activities that probably nice to do, nice to have, but they are not really essential in the main business or in the operation of the company. These are activities that happens once in a while, but it's not really necessary or desirable in the usual trade or business of the employer. So what are casual activities? Like, it depends on the company. If you're a construction company, out of the blue, you might think, well, I think I need a hairdresser or a massage therapist or a pedicure, manicure in a construction company. So, well, sometimes business owners are eccentric, but having a hairdresser in a construction company doing hairdressing activity, that is a casual activity, because a construction company doesn't need a hairdresser for it to operate its main business goals, its construction activities. So when someone like that is hired and it's not related, not directly related, not necessary or desirable to the usual trade or business, that employee can be classified as casual. And when the casual activity is over, when the employer said, let's stop this nonsense, I don't need a hairdresser in my company, they can tell the hairdresser this is your last day of work, without going through the due process, just cause and authorized cause. Why? Because the activity is casual in the first place. It is something out of the ordinary. And that's why the employer has the prerogative to end the casual activity. When the casual activity ends, the employment automatically ends. Now, a casual employee can become a regular employee after that employee has been doing the casual activity for at least 1 year, whether continuous or broken employment. No, broken employment means that he's hired for 1 week, then laid off for another week, then hired for 1 month, then laid off for another month. If that casual employee accumulates a total of 1 year of service, whether it's continuous or broken service, he will be considered as regularized casual. And as a regularized casual, even if the casual activity ends, he would be entitled to separation pay. So the hairdresser of a construction company who has been with the construction company for at least 1 year, whether continuous or broken, will be considered a regularized casual hairdresser. And when the business owners say, we don't need a hairdresser anymore, he is now entitled to 30 days notice and separation pay. Why? Because he is a regularized casual. So that's the main distinction of regular and casual. And HR managers, the HR department must know the distinction between regular and casual, because that's the basic rule under the labor code. Now, this distinction has been blurred because of the 1987 Constitution, which says that all workers are entitled security of tenure. So it is now a debatable issue whether a casual employee does not have security of tenure. But if we go back to the source, to the labor code, that's the nature of a casual employee. Now, going to other classification, probationary. Probationary employees are regular employees with a trial period. So I see a lot of companies that give 6 months of probationary employment contract to probationary employees. That's okay. But they miss the point when they give only a 6 months probationary employment contract. The essence of probationary employment is regular employment. A probationary employee is a regular employee in waiting. A probationary employee is a regular employee with a trial period of not more than 6 months of probationary employment. During that probationary period, he's being observed, evaluated, and appraise whether or not he qualifies for regular employment. So the end in view is for this employee to be able to be qualified. You don't need to have a 6 months probationary employment contract and then another regular employment contract. You can just have one single employment contract with a probationary employment clause or a probationary period clause of 6 months in a regular employment contract. So if the employee does not qualify, you just tell him, sorry, based on our probationary period or probationary employment clause, you did not qualify, so we are letting you go. We're not allowing you to continue anymore. That's the idea of probationary employment. Now, what about project? This is often the most misunderstood classification of employment. We'll discuss project employment in connection with fixed term or contractual employment later. Let's talk first of seasonal employees. So seasonal employees, they are hired as augmentation force during peak season. What are seasons? Seasons are periods within a year wherein there is a predictable surge in demand for additional manpower, like harvest season or planting season in the agricultural sector. There is a surge, of demand of more workers. Now, season has to be predictable based on empirical data of the company that during this period, there's really peak in demand. And then before that period starts, you can start hiring for seasonal employees. Now, when the season ends, there's no more reason for the augmentation workforce. So their employment automatically ends at the end of the season. But now there's a Supreme Court decision saying that if the employee is rehired for the next season, he becomes a regularized seasonal employee. That's a topic for another webinar. Now, let's go to project and fixed term. This is an area where most HR manager finds difficult to understand how to differentiate between a project employment and fixed term employment. Now, we have to distinguish them from each other because they have different effects. A project employee, you can repeatedly hire a project employee, repeated hiring of a project employee, and they will never become regular employee as long as you follow the requirements for hiring project employees. Fixed term employee, or who we call contractual employees, the moment you rehire them, especially if you repeatedly rehire them, they become regular employees. The repeated hiring or even the single rehiring of that employee will make them into a regular employee, which is different from project employment. Project employment, you can repeatedly rehire them and rehire them and rehire them, and they will never become regular employee. Why? What's the difference? Here's the difference. In this table, project employment and fixed term employment. In terms of work, project employment is attached to a project contract between, there's a project, there's a scope of work. When you have a scope of work, it means that it can be completed. You have to quantify the scope of work. If the scope of work is already finished, completed, done, and ended, then there's no reason to continue with the project employment because the employee is hired specifically to do the project based on the scope of work. Now, fixed term, an employee is usually hired to render a service, and there's no scope of work. The employee will just have to do certain job description and activities, and it's continuous, and it will only end when the end of contract date end, until end date of contract. So as you can see, what's the difference? Project employment is dependent on the scope of work. fixed term employment is dependent on the date. In fixed term employment, when the date happens, end of date of contract determines end of employment. That's where we get the word endo. So the primary the primary determinating factor for the end of employment is when that end of contract date occurs or happens. No, finish or not finish, you're not concerned with the scope of work. When the date happens, employment ends. That's fixed term or contractual employment. On the other hand, project employment is dependent on the completion of the scope of work. So if you want to hire a project employee, you must focus on quantifying and describing the scope of work. Because once the scope of work is done, completed, finished, there's no basis anymore to continue with the employment relationship. It's done. What will the employee do when the project is already completed? So I hope you can appreciate the difference. Of course, you can hire the project employee for another project. You can hire him repeatedly for another project as long as you can quantify and describe the scope of work. And you know that when the scope of work is done, let's say 10,000 units has been manufactured and delivered. That's how you quantify a project. So once you have manufactured and delivered 10,000 units of something, the project ends. It's not determinant on the date. The date is merely an estimate. It's just an approximation of when the 10,000 units would be manufactured and delivered. The date that you put in a project employment contract is just your target date, your estimated date of project completion. On the other hand, the date that you put on a fixed term or contractual employment is the date that will end the contract. Finish or not finish, the contract ends. So because of this difference, another difference is that when you have a project, you do a Gantt chart, no? You determine the number of manpower you need, you plan it, you do a manpower planning because you want to be efficient in completing the project. While in a fixed term, because you're going to deliver a continuous services until the end of contract date happens, no? The number of manpower you need is usually fixed to cover the services that is required. So these are the difference, no? And I hope you'll be able to understand so that when you hire people, you know whether they are fixed termers or they are project employees. Because if they're project, repeated rehiring is not an issue. Fixed term, repeated rehiring will make them regular employees. Okay, so I think that's about it. Okay, let's go to the question and answer.
Here are a lot of questions, attorney. So let me read them. This one is from Ace Gatchalian. Question: our employees want a proof where we can find the management prerogative.
Mm-hmm.
2, can we impose a certain clause in the employment contract wherein the employee said that he only signed the last page and not the entire pages of his employment contract? Medyo marami pa ng question. Let's just answer for a few of his questions so that we can move on to other questions, attorney. So those are the 2 questions first.
So signing only on the last page, it's okay. That's usual. Especially now that we're now doing digital contracts, digital document or electronic documents. Mm-hmm. But signing on all the pages is merely a best practice. But it's acceptable to sign only on the signature page. Signing on all the pages is a best practice to ensure that that the employee was furnished with the exact a copy of the contract that he signed to prevent any insinuation that there was an insertion or a substitution of pages.
Okay, I'll move on to another question from a different participant so that we can also address questions from others here.
Yes,
Okay.
sure.
Attorney, what resources or professional network can HR managers tap into for staying updated on evolving labor laws and legal best practices in the Philippines?
Well, we have several HR organization. I am a member of the People Management Association of the Philippines, or the PMAP. That's one. That's a formal organization. There are other organizations like the Philippine HR Group, which is an online group. There are many associations. Be a member of at least one association of HR. Also, ARIVA has a community. You can be a member of the ARIVA community on Viber and in other platforms to keep yourself updated with the
Yes.
latest.
Yes, thank you so much for that. Here's another question. Can we take disciplinary action against an employee for making negative comments about the company on social media?
Yes, yes. But of course, it depends on the situation. This is about freedom of expression. As you know, we have the Bill of Rights, and under the Bill of Rights, freedom of expression, free speech is a guaranteed right of all citizens. But even as we have the right to free speech and freedom of expression, the one who's on the receiving end of a defamatory, a libelous speech or expression has the right to defend his honor, his reputation. So there's a balancing act in this regards. So if the remarks of the employee in social media is really defamatory and libelous, then the company can not only exercise and impose discipline on the employee, but also file a libel case or cyber libel case against the employee who committed the wrongful act. Now, if that's why you have to weigh, no, what type of remark is that. So if it's just a rant and not defamatory, then it might be too harsh.
Yeah.
To file a cyber libel. The cyber libel complaint might be dismissed, and dismissal might be too harsh. So you might be able to impose certain discipline, maybe suspension, maybe warning on the employee. And then the best thing to do is to have a policy, a written policy on social media, and to give employees an outlet. No, you cannot censor, you cannot totally prohibit employees from expressing themselves, from having grievances, but you can regulate through a company policy, a written company policy. You can regulate and you can tell the employee, this is the proper venue, this is the proper channel. You can ventilate your grievances, your complaints.
Okay, thank you for that, Torny. Here's a question. This one's interesting. The services of a company guard was contracted using an open date independent contractor agreement for almost 2 years now. He is not part of the payroll but is being paid on a daily basis. There's no social benefits and deductions. Is there an employer-employee relationship?
Okay, good question. Now, independent contractor, when you basic rule, when you hire an independent contractor, the independent contractor must be independent, meaning he does his work based on his own account. He's an expert, he's a specialist in the field, and you hire him. And one indicator that is truly an independent contractor is that he is duly registered as a self-employed taxpayer. Every time you pay him, he issues an official receipt. That's an indication of of an independent contractor. Well, like me, I'm an independent contractor. So when a client gets my services and pays me, before they pay me, I send a bill. So the security guard must send a bill for his services. And when the company that hire him receives that bill, the company will make payments. He should not be in a payroll, and then ask the security guard to issue an official receipt. That's how you engage an independent contractor, so that there's no doubt. Now, when there's doubt as to what is the actual nature of the relationship, whether it's employer-employee relationship or independent contractor-client relationship, then what is applied primarily is the control test. Now, the control test is part of the four-way test to determine whether the relationship is one of employment or other type of work arrangement. But the most important test in the four-fold test, there are four tests, is the control test. And what does the control test says? If the worker is treated like a subordinate, in the sense that his work is being directed, he's receiving instructions from a superior, he is subjected to company policy, he's required to have a certain schedule, perform certain activities in accordance with the strict instructions of the one who hired him, then that means that his means, manner, and method of performing his job or work is controlled by the one who hired him. And when there's control over the performance of the day-to-day task of executing the activities, performing the activities, then there is employer-employee relationship. So the contract will not hold water. Even if you have a written employment contract that says that the security guard is an independent contractor, the control test will be applied, and most probably the security guard will be considered an employee. So moral lesson of the story, if you want to hire an independent contractor, hire a legit independent contractor, one who has official receipt and one who has registered himself as a self-employed taxpayer with a BIR.
There you go. So I hope that answers your question to our dear participant. We have another question here sent directly to us. Here's the question. Is it legal to adjust from higher to lower performance-based incentive allowance depending on performance if the employee fails the evaluation and is transferred from higher to lower positions?
Okay, that's a complicated question because that might involve demotion. So let's focus first on the incentives. So to be fair, there has to be some sort of a written policy on incentives, and you have to differentiate an incentive from a benefit. We have a principle called non-diminution of benefit principle, wherein the wages and benefits of the employee, if they have been guaranteed, cannot be unilaterally reduce, diminish, or revoke by the employer. So that's what is called the principle of non-diminution of benefits. Whatever is the guaranteed, whatever is the established wages and benefits of the employee cannot be reduced, diminished, revoked, as long as it is classified as a part of his wages and benefits. Now, incentives or rewards is different. As long as you can differentiate between an incentive and a benefit, that's different. Incentives can be changed once the incentive cycle runs its course. No, an incentive could be if you hit this target, you will have a free trip to Hong Kong. So is that a benefit? Well, it's not guaranteed. You're setting a target, so you can change it next year. You can change it. No longer Hong Kong, free trip to Baguio, because you're cutting costs. So for the next cycle, he say, now the incentive is no longer trip to Hong Kong, but trip to Baguio. Cutting costs. That's allowed because why? Because that's not a benefit. As long as it's not a benefit, you can change the rules once the incentive cycle is over. Of course, you cannot change the rule in the middle of the cycle. That would be unfair, no? Because if the employee is almost going to achieve the target and is going to get a trip to Hong Kong, then suddenly you announce, no, it's no longer Hong Kong, it's Baguio City now. So that's unfair.
Okay. Thank you so much for that. Here's another question. Attorney, if an employee left, like absence without leave, without finishing the contract, and he comes back to continue the contract, is it possible to re-enter the deal?
Yeah. Well, okay. First of all, you have to determine what happened when the employee left. That's the problem when you have a relationship and there's no closure. Wow, hugot ano? Hugot.
Para iba po yata yun, attorney.
Yeah, because employer-employee relationship is a relationship. It's like
Yes, it is.
having a magjowa or boyfriend-girlfriend relationship. If you do not put a closure and then your boyfriend or your girlfriend suddenly ghosted on you for 6 months and there's no closure that you have broken up, and then she or he returns to you and you don't have a closure, what's your status? What's your status? So you have to have a closure when the employee leaves. That's why when employees went on a wall or a prolonged absence, you have to check on the employee and even send him a notice to return to work. You can even initiate disciplinary action just to put a closure. Because if you don't put a closure, then it's an open-ended relationship. He can still come back and claim that I'm still your employee. Like a boyfriend who has ghosted you and then say that, no, you cannot have a different boyfriend. We're not yet done with each other. We have no closure. I'm still your boyfriend. So it's like that. You have to put a closure. Then, if there's a closure already and the employee wants to come back, then you do a recontracting, a rehiring, if you still want him to do the job. Unless if you haven't learned your lesson yet. Of course, that's called marupok.
Well, so employers can also be marupok, attorney.
Yes, if they don't learn their lesson.
Here's a question that's a bit connected to that. Can AWOL employees still claim their benefits?
Yes, of course. Yes, of course. If they have earned that, then they can claim it. Of course, there are, if the employee has accountabilities, then you can offset the accountabilities of that employee against his final pay or whatever benefits that he is entitled to receive. But if you have not done your homework and not determined or made an audit to determine if the employee is accountable, then how can you offset the accountabilities if you haven't gone through the work of determining the accountabilities of the employee? So therefore, under contract, under labor law, you have to release the final pay and whatever receivable the employee has, because it's his right.
Okay, here's a question. This one's still interesting, attorney. It was sent directly to us. Can you please explain loss of trust and confidence as the head's immediate reason when he wants a manager or a vice president out, and we in the HR and legal department have to deal with the complaint? He's in a predicament.
Okay. Well, you have to study the jurisprudence or the cases decided by the Supreme Court on what is enough basis for loss of trust and confidence. Now, there are certain glaring situations wherein it's obvious there is loss of trust and confidence. Like, for example, concealment, conflict of interest, or let's say when you conduct an audit and the the employee falls short. However, when it's performance related or the delivery of expected results, it's a little bit complicated, no? Because if there are valid reasons why the employee, the manager, or the supervisor was not able to deliver the expected output or results, then loss of trust and confidence would be too harsh, no? When you dismiss an employee. For example, clear example, COVID, lockdown. So there are targets, sales targets, quotas. But then you say to the manager, you did not deliver the quota or the target. But if there are reasonable basis or justifications why the manager or the supervisor was not able to deliver the expected result or the promised results, then you cannot dismiss the employee based on loss of trust and confidence. So it depends on the facts and circumstances. The loss of trust and confidence must be reasonable. It must be based on reasonable scenarios, no? And of course, if there are several managers of the same rank doing the same activities, the same function, you should also check the population. If all of them are failing or not achieving their goals, then why would you selectively apply the policy of loss of trust and confidence on only one manager when all of them are not hitting their targets or quotas? So those are some of the considerations that you must have. So in other words, it's not enough that the management say, that the owner say, I've lost confidence in you. There must be evidence. There must be substantial basis. There must be reason and justification for loss of trust.
Okay, thank you for that. Another question here. Here's the situation. Employee was a supervisor, submitted resignation letter, but in the middle committed a wool and did not finish the 30-day compliance. Supervisor left unfinished tasks or work without proper endorsement. Now,
Okay.
the superior does not want to sign the clearance and the supervisor is requesting for COE. Is it okay to hold the COE for more than 3 days?
Okay. Well, nandiyan na naman tayo sa walang kamatayang COE. Okay.
Yes.
Bestseller yan, the
The
Certificate of
question,
Employment.
yes.
Well, it's like this. The COE is not clearance. COE and clearance are not one and the same. You can release the COE because there's a labor advisory 06-20 that says that within 3 days from the request, whether the employee is still connected or has already resigned or is dismissed, within 3 days, the employer must release the COE. What does that mean? It means that the COE is not clearance. You can put in the COE that you will release within the prescribed period of 3 days a disclaimer that this certificate of employment requested by this employee is not a clearance, or that the employee is still undergoing clearance, or the employee has not yet been cleared. Okay, so that's what you can do. So you can comply with Labor Advisory 06. So, and you have to distinguish between the clearance and the certificate of employment. What is a certificate of employment? It's a service record. The requirement under Labor Advisory 06 for the content, no? What is the content of a certificate of employment? It shows the starting date and ending date of the employment in case he's no longer connected. If he's still connected, then you can say up to present, he's still an employee. And then what else? a brief description of his position and what does he do in that position. So one sentence description, no, of what the employee performs while occupying that particular job position in the company. That's all. That's the only content of a certificate of employment. Nothing more, nothing less. So it's not a clearance. So if you just want to make sure that the employee cannot use it as proof of clearance, and put a disclaimer that the COA is not a clearance.
Mm-hmm. Okay, thank you for that. Another question, marami pong question, attorney. Here's a question. Under the incurable prejudicial disease, the employee availed the SSS benefit of 120 days due to his sickness, and he is no longer with us. Attorney, is he entitled to separation pay?
Separation pay for incurable disease. Well, how was he disconnected with the company? Was he terminated, or did he resign? If he resigned or if he retired, then no separation pay. Voluntary resignation does not entitle an employee to separation pay. Or if he's dismissed through just cause, separation pay because of illness is only given when the conditions are met, when it is the employer that is terminating the employment and the employer has sufficient basis based on a medical certificate issued by a public health authority. Other than that, there's no ground for separation pay as a legal ground. No? But of course, if you want to be generous and humanitarian, you can give financial assistance, which is
Attorney,
different.
nagbigay ng update ng ating participant. He said the employee did not resign and he's not terminated. But he said he's no longer with us. Can you explain this further to that participant? If
So
he didn't
that's
resign and he's not terminated, how come he's no longer with you?
yeah, that's the closure. It means they have a cool off period. So the reality is that if you have not dismissed and he has not resigned, and there's no indication that he has abandoned, no, or involuntary resign, there's this gray area. According to the Supreme Court, there's a gray area called informal resignation, wherein the employee did not submit any resignation letter, but because of a text message or an email or a remark that he doesn't really want to report for work anymore, it's considered that the employee has informally resigned, even without a
Attorney,
resignation
here's the
letter.
clarification. He said he's no longer with us because his health does not permit him to come to work. So he's not allowed to go back to work because of his health.
Okay, so he's still an employee. He's still an employee, and unless you terminate him because of serious illness under Article 299 of the Labor Code, then he is still your employee.
Mm-hmm. So no separation pay because he's still employed.
He's still employed.
Yes. Thank you for clarifying that. We have someone raising their hand. Lely, please unmute, and if your camera is still turned off, please turn it on so that we can hear from
Hello
you.
po. Hello po, good afternoon.
Yes.
Good afternoon.
Miss Ellery po. Actually, meron kaming employee, na-convict siya ng rape. So, nakakulong siya ngayon, currently
Correct.
detained. So, paano po kaya yung magiging dismissal namin sa kanya if itatag namin na AWOL?
Yes, correct. Absence without official leave, because you cannot terminate him based on rape unless he has raped someone related to your company, like a colleague, a worker, an employee, or someone connected, because that would be a serious misconduct. But if he raped someone who is not connected in any way to your company, you cannot terminate an employee based on conviction of rape. The only ground for you to terminate him would be prolonged unexcused absence.
Oh.
Or absence without official leave.
Aleli, you're on
Yes.
mute there.
Um, Bale sir, okay lang po yun basta magpadala kami sa kanila ng letter.
Yes, yes. So it
Okay.
doesn't matter if he's deprived of liberty because he's detained or imprisoned. It's not your lookout. No, he has to explain. If he says that, sorry, I cannot go to work because I am imprisoned or detained, it's not a valid excuse.
Magpapadala rin po ba kami sa may presinto kung saan siya nakadetain or sa last
Yes.
registered address pa?
Well, you can do both. Better if you can do both.
All right po. Thank you so much for that, attorney.
Thank you so much, Aleli. Okay.
Mm-mm.
Moving on to a few more, probably last two questions, attorney. Here, this is a question from Elena Bacalondo. Are government offices governed by the labor laws? I think he's referring to the same labor laws that we have for private companies.
No, they have the civil service law. Now, government agencies are governed by civil service law. They are under a different set of rules and regulation laws than the private sector. There are certain government owned companies that are governed by labor laws, but these are proprietary companies that are merely owned or majoritarily controlled by the government, which is a different case. They're still considered part of the private sector.
Okay, thank you. We have another participant who's raising their hand. Elenita, please unmute and turn on your camera if it's off.
Hi, good afternoon, attorney. Yeah,
Afternoon.
my question is, if we're going to transfer employees from a single proprietor company, and then we'll put up a corporation company, my question is, what will be the tenure of our employees? Are we going to back to zero? And are they entitled to separation pay to transfer to a new company, a corporation?
Well, there are two possible approaches to this situation, but the traditional or the what you call this, the ordinary approach is that to close down the sole proprietorship because the corporation is a new entity. No, it is not necessarily the continuation of the sole proprietorship because when you form a corporation, the corporation has an identity of its own separate from the owners. So what we have here is a closure of a company, which is the sole proprietorship. So since it's going to close down, employees who are affected will be entitled to separation pay. Now, if you want them to be employed by the corporation, you send an invitation. They would have to apply. But of course, you have to settle your obligation with them first by paying them their separation pay. And then when you invite them to apply, it's a different company, it's a different employer, it's a new and different employment contract. You can start them from zero tenure. No, so their previous tenure will not count. No, under that scenario. There's another way, but it's more complicated, wherein you can carry over the tenure. But since it's complicated, it's better you get the advice of a lawyer. For the it's called you carry over the tenure. So the successor employer, the new employer, the corporation would absorb the tenure of the employees whose company has closed down. So they will not begin at zero. They will begin because their tenure has been carried over. If they have been 5 years with the closed company, the sole proprietor that closed down, then that will be an obligation of the new employer, the corporation, that the employee would be considered to have additional five years of tenure, even though he started only this day. No? His day one is only today, but he brings with him 5 years of tenure. So that's a complicated transaction. Better discuss that with the lawyer.
Thank you, Attorney Paul, and thank you, Elenita, for asking that question. And I think we're down to our last question, and this is really good, Attorney. I think this person who is asking this question is asking for help. So this is the question. Attorney Paul, how do we deal with an abusive HR manager and HR team?
First, well, you resign.
Ay,
There are better employers, better companies out there that will treat you properly. So that's my first advice. But if in case you don't want to resign, or for one reason or another, you are not mobile in terms of looking for employment, it's difficult for you to find a job, then of course, who's higher than the HR department? It's the owners of the company. So you submit a petition to the president, to the CEO, to the owners, to the board of directors, and submit a grievance.
mhm.
Because the HR team are also employees, and they are, unless they are the owners, and they are subject to the same company policies, the same company discipline, and they are not above the law, and they are not above company policy.
Okay, thank you, Attorney Paul. I know we still have a lot of questions here in the chat box, and some were sent directly to us. We're very sorry, but because we lack time already, actually, we went over time for 30 minutes already. But thank you, Attorney Paul. You have been very generous in answering the questions and sharing your knowledge to all of our participants. Because of that, we would like to present you with a certificate. Let me just read this. ARIVA Academy Learning Development at its finest gratefully presents the Certificate of Appreciation to Attorney Apollo Sangalang for imparting his professional expertise, valuable insights, knowledge, and wisdom as resource speaker during the conduct of online learning session entitled Common Legal Issues Affecting HR Managers, HR and Labor Law Challenges in the Philippines and How to Overcome Them. Given this 4th day of September 2023 via Zoom conference. Signed by J.M. Matienzo, Chairman and Chief Strategist Learning Event Producer, and Michelle Irish Malonda Samson, President and Chief Learning and Development Strategist. Ladies and gentlemen, let's give a round of applause to our speaker, Attorney Paul Sangalang. I'm seeing a lot of thank yous here in the chat box, Attorney. Ang bilis gumalaw ng chat box. Seeing a lot of thank yous there saying that they really learned a lot. Ang dami daw learnings today na nakuha from our speaker. Maraming salamat, Attorney. Now, before we end this webinar, let's invite everyone to have a group photo. So please, if your camera is still turned off, turn them on right now. Now's the time to turn on your cameras. There you go. Show us the beautiful faces of our participants. And then let me call on our technical director who has been helping us since we started our webinar this afternoon. So Direct Dana, can you help us out?
And thank you so much for your introduction, Miss Kate. Hello, everyone. Again, please open your cameras for 2 shots of group photo. Okay, for our first one, we're gonna keep it nice and simple. Can you please give me 2 thumbs up? Together with your biggest smiles, of course. All right, is everyone ready? All right, and 3, 2, 1. There we go. Thank you so much. And for the second one, can you please give me 2 finger hearts, like so? Yeah, still pair it with your biggest smiles, please. All right, and 3, 2, 1. There we go. Thank you. Thank you so much, everyone. Back to you, Miss Kate.
Thank you so much, Direct Dana. in behalf of everyone from ARIVA Academy, I'd like to say thank you to all of our participants for this free live webinar. Maraming salamat for being with us. We learned a lot from our speaker, but we also learned a lot from you because you asked a lot of questions, interesting questions. So maraming salamat for sharing those situations with us. Thank you, and we are looking forward to welcoming you again in our next learning events. Thank you. Good afternoon, everyone. Stay safe, stay dry. God bless you all.
a bridge company.